Hello and welcome to my series of conversations with men and women whose ideas, vision and philosophy define our contemporary world. My guest today has been described as a humane firebrand who had a youthful penchant for Perry Mason. Of course, his very distinguished legal career traversed a long journey to the Chief Justice of the Supreme Court and currently Chairman of the National Human Rights Commission. I'm delighted to welcome Justice Anand.
Thank you.
Justice Anand, from Perry Mason, a long journey to the real world of the judiciary. We're recently sort of reeling under the press reports of these non-bailable warrants against the Chief Justice and the President of India. Doesn't that sort of dismay you in very substantial terms?
Well, that does show that there's something wrong somewhere. I won't say everything wrong everywhere in the judiciary, but something wrong somewhere. That the magistrate, without even looking to the type of complaint, should sign the warrants. That itself is a very disquieting feature.
In what ways do you think it somewhat diminishes the ability of the judiciary to act in the manner that you did, for example, when you were pushing the CNG? There's been this sort of traditional dichotomy, contradiction, questions on the role of the Supreme Court. But when you find that your own house is in such disarray, how does that pan out?
That does require very hard decisions. And this is no excuse that the magistrate was overworked. Because that is generally the excuse put forward, oh, sorry, I signed it without looking into it. I had 100 of files with me. That's no explanation. And the very fact that the allegation is that 40,000 rupees was paid as bribe, that is the worst thing. Mind you, so far as judiciary is concerned, its strength lies in its credibility. And if credibility is eroded for any reason whatsoever, around any account, that affects the image of the judiciary.
What is the core problem? 23 million plus pending cases, not enough judges?
Well, not enough judges is indeed the core problem. Mind you, we have a population of over 1 billion, and the total number of judicial officers in the country is less than 13,000, which works out to almost 11 point something per million population, as compared to over 125 judicial officers per million in America, and about 90 in United Kingdom. That is one part of it. But even those posts have remained vacant. At any given point of time, in the subordinate judiciary, there have been as many as 1,500 vacancies, vacant posts. And in the high courts, almost between 120 and 150 posts are lying vacant.
Why are they lying vacant? Is it just sort of lack of political will, lack of judicial will? Not enough good people want to be in the judiciary?
It's a combination factor. But even after the names are recommended, it takes a long time for them to be processed. That procedural delays have to be taken care of. There was a time frame given once by the Ministry of Law and Justice. But it has only remained on the letter.
Are there enough, you think, that even if all the vacancies were filled, are there enough vacancies, are there enough slots that would take care of the system?
Yes, there are. Even today, there are almost 150 vacant positions of the High Court judges in the country. Even in the Supreme Court, there are 2 vacant positions.
Going back to this aspect of judicial activism, in what ways did you feel justified? You know, of course, today as we sit here and record this in Delhi, and I mentioned to you before the program that you must be a proud man. The air is cleaner, and we take a deep breath, and there's less visible pollution, and that was really a major contribution that you made. But how do you justify to yourself intervening in what was really the preserve of the executive, and the executive wasn't doing?
Mr. Mehrotra, let me say, activism I don't think is the proper word. I would say that judiciary ceased to be passive onlooker. Now, why the judiciary intervenes, I can just tell you supposing a citizen comes to the court and says, well, I went to my legislator and he says, I have no time, we'll meet at the next elections. He says, with my problem, I went to see the minister who is from my district or my constituency. And Darban says, Sahab is busy, he can't see you. And if he came to the court and court also said, sorry, not our domain, he would take to the street. And the casualty would be the rule of law. So judiciary can't permit that. And judiciary only acts as an alarm clock, which I have said so often and even in my judgments. It's only an alarm clock to tell the executive, look, you are obliged to do this, you have not done it, now do it. It's not a timekeeper. And that we have been able to wake up certain departments of the government to do their job has been a contribution of the judiciary by ceasing to be passive.
Isn't there a risk that initiatives such as this might provoke the executive at some point, as has happened frequently in the past, or it has been believed to have happened in the past, that they then begin to pack the judiciary with pliable judges, with judges that are more sympathetic to the interests and concerns of the judiciary? Today, this morning, even as we record this, there has been, the judgment in the Bofors case, and many would argue that, its timing has enormous political significance. So there is that inevitable brush with the processes of politics and the processes of the executive.
Well, there is danger that so far as the executive is concerned, it might perceive the action of the judiciary in asking them to do their job as interference, as irritants. But that is necessary if you want to preserve democracy. For preserving democracy, it is essential that the rule of law is maintained. And you can't maintain rule of law if the authorities abdicate their duties and do not care for the citizen. There have been attempts in the past to pack up judiciary, but fortunately, Chief Justices in the High Court and even in the Supreme Court have stood firm in not taking persons who they thought were not suitable for the post.
But why do you think that happens? Is there something to do with the fact of the office of it? Because the government may make an appointment, obviously thinking this person is going to be pliable, and as he moves up the ladder and he becomes Chief Justice, as you did, and then he says, well, I'm Chief Justice now, or I'm a judge of the Supreme Court, and I have to uphold the highest traditions.
Well, they take oath under the Constitution to uphold the Constitution and the laws, the unity and integrity of the country. This thing even happened in America. President Roosevelt tried to pack the judiciary. But it doesn't work. They realized it. And here also, I think attempts were made, but never pursued. There may have been some odd cases here and there, but that's about it.
But in general, why do you think it doesn't work? I mean, the people take all kinds of oaths. A police person takes an oath and yet doesn't prevent him from being corrupt. So is there something in the spirit of the office and the nature of the office that one is awed by the responsibility of it? How did you feel?
Yes. In the nature of the duties and the assignments. When you move from the bar to the bench, you do realize that there's going to be a lot of sacrifice so far as money is concerned. But then this is an assignment which gives you an opportunity to put in reality what is called justice.
In what ways is justice, you think, reflective of the spirit of the law rather than the letter of the law? You know, when you make a judgment in the Bihara case on compensation for families of victims, or you sort of initiate fast-track courts, you're obviously acting beyond a limited empirical interpretation of the law.
Well, life of law is logic. And the judiciary has to respond to the hopes and aspirations of people. Those hopes and aspirations change from time to time. What was acceptable to the society, say 50 years ago, may not be acceptable now. And the judiciary can't say, well, no, we'll live in that past age only. That is how law has developed everywhere. India is not the only place. In America, way back in Dred Scott's case, they called Negro a chattel. And it took them 100 years to say that to call Negro a chattel is dehumanizing concept. In India, in 1950, when the Constitution came into force, in Gopalan's case, the Supreme Court said, we will interpret it only with reference to the particular article of the Constitution. But then later on, it developed, they said, no, it has to be looked at in a more liberal way. And in Maneka Gandhi's case, they said, yes, law is fine, but it must be just, fair, and reasonable. So that is how the law develops.
This is the passport case?
That's right.
Tell us about the passport case, just for our viewers that you refer to it as.
You see, she was denied passport, and the question was whether she has the right to receive a passport to travel. They said, within reasonable restrictions, this is a right. And if you say that the procedure prescribed by law permits you not to give it, then that procedure has to be tested on the anvil. Is it just, fair, and reasonable?
Have you, in your long and distinguished career on the bench, sometimes felt inhibited by the letter of the law, that you knew that if you follow the letter of the law, justice will not be done? Can you give us an example? Where you had to turn to the spirit of the law rather than the letter, and that's something that the Supreme Court enables you to do.
Now, molded the law in that way, yes. There were a couple of cases.
So what would be a significant one?
Well, there was this case of a lady, Geeta Hariharan. If one went only by the letter of the law, the statute provided that the mother comes in only after the father. And the word after was being interpreted and considered means after his death. I interpreted it in that case to say, well, after is in the absence of. If he is absent for any reason whatsoever.
This was the case in which Geeta Hariharan had sought the right to present herself as the
guardian of the minor children.
You have been an advocate, a great advocate of gender issues, and sometimes it's just been ascribed to the fact that you have 3 daughters, and that makes you even more sensitive to the issues. You've authored a book with your lawyer daughter on gender issues. To what degree do you think that purely legislative or legal imperatives can actually bring about change? We in India have some of the most progressive legislation per se on women's issues, but it hasn't really translated into on-the-ground realities.
You're quite right, absolutely right. And this requires change of the mindset of the society, more than legislation. Well, the parliament can tomorrow legislate. Well, today, I think, is the last day it can legislate today, that women of India are hereby empowered. What does that mean? Nothing. It's the mindset of the society which has to change. And that can also change with the aid of judicial interpretations. But it's the civil society which has to respond.
What kind of initiatives and possibilities would you see now that you're outside the judiciary? You're still head of very, very important, distinguished constitutional office as chairman of the National Human Rights Commission. What tangible, concrete initiatives do you feel that can still be made, still be done, that would make this kind of difference?
Create awareness. You see, unless the poor woman in the village down in Kanyakumari knows what her rights are, how is she going to even agitate against those rights and seek their protection? So first thing is because we have plenty of legislation in this country, perhaps much more than any other country, and they are socially relevant legislations, very useful ones, pro-women. There are legislations against untouchability. But the ground reality is that it still persists.
Justice Anand, what role do you see for the National Human Rights Commission to further some of the kinds of agendas that we have been talking about?
You see, as you know, under the Act, the Commission is a recommendatory body. But because of its credibility of the Commission, thanks to all my predecessors, the citizen is looking up to the Commission as a forum where he or she can go and ventilate the grievances. And I'll tell you, Mr. Mehrotra, a very simple thing. Earlier, in the earlier years, in the first year, the Commission received almost about 500 complaints. Last year, there were 72,000 complaints. Not that all the complaints can be looked into and redressal given. Some are just frivolous. But the very fact that those many people are coming up to the Commission shows their confidence in the Commission. And therefore, the recommendations which it makes carry a great weight. And they almost border on the verge of directions, those recommendations. And judiciary has been very supportive because we are only supplementing the work. Now, the protection of human rights is the obligation of the state. When the judiciary issues various writs and directions and orders for enforcement of fundamental rights, it is doing that job. And we are only supplementing the job both of the judiciary and the executive in protecting, rather better protecting human rights. We have taken up many causes, gender-sensitive causes, trafficking in women, girl child, child sexual abuse, bonded labor. These are all areas which perhaps the courts will look into only a specific instance or a specific case. We look at it in a broader canvas.
I think the National Human Rights Commission was most visibly in the public domain after the events in Gujarat. It has been reported that your current opinions may have been somewhat at variance with the previous chairman of the Human Rights Commission. To what degree is that perception valid?
I don't think it is valid. There has been no change of perception except in the manner in which we try to deal with the situation. But so far as the interventions are concerned, I would rather not say anything because the matter is still sub judice.
How might the National Human Rights Commission, in your view, have handled it differently?
In what way?
You said that there was a difference in perception of how the National Human Rights Commission might have intervened in Gujarat at that time and how you might have intervened. So
well,
what might have been the difference?
To begin with, when the trials were to be initiated, or the first information reports were to be lodged, at that time, the Commission could have taken some more active role which could have helped the victims of violence.
In what ways do you think it might have intervened?
Well, if there was intervention at the trial stage, when the trials commenced, rather than when the trial had gone what for.
What about the Best Bakery case?
Well, that is sub judice. That is sub judice. But I can tell you that we intervened in the Best Bakery case because there were three basic factors which were bothering us. One, it was the credibility of the criminal justice delivery system which was in question. The concept of fair trial, because we at the Commission believe that the fair trial is a constitutional imperative. And the concept of fair trial requires not only fairness to the accused, certainly fairness to the accused, but also to the witnesses and the victims of crime. And we found that that fairness for the victims and victims of crime, in our perception, had been violated. The third was the role of the judicial officer. Is he there to sit only as a mute spectator, or is he there to control the file and the case? For example, if the witnesses, after witnesses turn hostile, what is the role that the judicial officer must play? And since in this country we don't have any law to protect the whistleblowers, so we requested the Supreme Court to lay down some guidelines till legislation is framed.
Doesn't this sort of again illustrate the failure of the legal and justice systems to deliver justice to sort of people who are individually or collectively charged formally, and even as that is offset in some ways by let's just call it judicial responsibility or judicial social responsibility. So on the one hand we see enormous successes of the judiciary in that realm, and yet a complete failure and collapse, not just the judiciary but the whole justice system, where you inevitably find that there is a great deal of tamasha and a great deal of attention when someone is being arrested or the process of prosecution starts, and then suddenly it just sort of fades and limps away into collapse, and we don't know what has happened till 18 years later. A prime minister who lost an election on an issue is acquitted before another election.
You see, judicial reforms are necessary to make the system work. Yes, the working of the criminal justice delivery system is much to be desired. There are many lacunas in it. Why is it that in all important cases, almost all important cases, witness after witness turns hostile? Is it that they are taken over by materialism, by pressures, or by other considerations? In either case, the casualty is justice. If the victim of crime does not get justice, well, for that victim, the justice delivery system is nothing but a farce. And therefore it does require a re-looking into the criminal justice delivery system. And I'm sure since we have raised this issue and the Supreme Court has treated it as a public interest litigation, they will certainly act and lay down some guidelines till the legislation is framed.
At the end of sort of the day, do you despair? Do you see possibility and hope that reform might happen, that reform is imminent?
I'm an optimist, and I believe it would happen. And the judiciary has always stood up to stand its challenges, and I'm sure the executive would also do so. Because unless both the judiciary and the executive act in harmony to bring about reforms, reforms can't come.
Tell us, the Bihara case was a landmark judgment in the annals of the Supreme Court and one of your major judgments. Tell us about the case and the judgment.
You see, in this Nilapati Behra's case, it was a very unfortunate case. This lady is a vegetable vendor. She had a son. That son was picked up by the police somewhere in the state of Odisha and taken for interrogation to the police station. At the police station, he is tied to a tree and thrashed. This woman goes to the police station, pleads with those people that, look, he's an innocent boy, he's helped me only, he's not involved in any crime, and don't treat him like this. They don't hear her cries. They don't respond. She comes and complains to various people, but she gets no help. She again goes to the police station and finds that the son has been very badly beaten up. He's still tied. She comes and tells some local lawyers and others. They said, all right, we'll find out. Next day, the police says that the boy has run away from police custody, and his body is found on the railway track. A train has gone over. So what was being given out was that the boy was so ashamed of his activity that he went and committed suicide. But this woman said that the way he had been beaten up, there was no way that he could even walk, let alone run to the railway track. She wrote a letter to the Chief Justice, which was assigned. We found that it did require probe, but the postmortem report and others
had been fixed.
They had been fixed, and there was nobody coming forward. Obviously, what has happened in the precincts of the police station, you only have the police witnesses. And the tie is so strong, the brotherhood, nobody's going to speak that, no, this constable did this or this inspector did this. So we asked the sessions judge to hold an inquiry, and also asked the entire thing to be looked into by a board of doctors. In that they found that all those injuries by the train, running over by the train, were postmortem injuries after he has died. It was the dead body on which this train has gone.
But the significant part of the judgment was that you ordered compensation for the family.
Yes.
I mean, apart from the police being brought to justice.
Right.
And
you see, one argument which has been raised here time and again, and in fact that is the reservation of Government of India to sign the protocol on torture, has been that our constitution does not permit payment of compensation. So I try to draw a distinction between payment of compensation, damages, and making monetary amends for the lapses of the executive. What I said was that the civil law has a purpose, and in the public law jurisdiction is to be invoked wherever the public authorities have to be civilized. And to give monetary amends for such violations is a compulsion of judicial consciousness rather than the other way.
your most sort of gratifying, satisfying, profound moment on the bench?
It was, indeed. It was. And thereafter, this has been followed in various other disciplines. highest court in New Zealand, in Australia. They have followed it. They also had a similar problem that the Constitution does not permit payment of compensation.
Justice Anand, thank you very much. That's been a great privilege.
Thank you.